I am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Welcome back to another edition of Ag Law Today, and we have Deborah Kaminetzky talking all things advanced directives today, coming from us live out in Nassau County, New York. Deborah, how everything's going in your neck of the woods?
Very well, Carrie. Thank you for having me.
So tell me a little bit more about you and your law practice.
My practice is located in the southwest corner of Nassau County, very close to Queens, which is New York City. I primarily do matrimonial, negotiated or mediated, and estate planning. The sweet spot of that, of course, is prenups, but we're not talking about that today. Today we'll be talking about advanced directives, which I always ask people to get done. I know people who are in their 60s who still don't have them, but I do advocate even college kids getting them, because it's very, very important for you while you're alive, as opposed to a will, which is after you pass.
So I think that you're pretty passionate about advanced directives. Tell us a little bit about where that's rooted from, and let's just get to the chase. What exactly is an advanced directive?
One of the reasons I'm passionate about it is because I've had parents and in-laws who have unfortunately passed away in different ways, some from very long illnesses, some just basically had a heart attack and passed away. And it's really important for you as a person to be able to decide who is going to make decisions for you if you cannot.
Yeah, Deborah, I've had clients of mine, their parents are in a nursing home and they're losing capacity, and they needed to go to court and file a guardianship proceeding. And I don't think a lot of people understand that if you're in that situation, you don't have a power of attorney, it could put a big financial burden on your family to have to seek court intervention just so they can make decisions on your behalf.
Right. Well, in New York, we have several different types of advanced directives. The most common are the healthcare proxy, the living will, and the power of attorney. We also have some other laws if you are in a hospital, which I'm not going to get into today, where you don't need an advanced directive, but in those, it's almost as if it's an intestate situation, that the law states who can make those decisions for you. If you want to choose who is going to make the decisions, you need the advanced directives.
All right. So what you already mentioned it briefly, but exactly what are the different types of advanced directives? And I know that the law does vary a little bit on this from state to state.
Okay. I guess we'll start with a healthcare proxy, if that's okay.
Yeah, absolutely.
Okay. So a healthcare proxy basically states who can make decisions for you if you become incapacitated. Now, your personal physician normally is the one who would determine that you are incapacitated, and the healthcare agent would need to act. This is different from a HIPAA release, which enables people to find out information about your medical care. But I normally put the HIPAA language into my healthcare proxy to enable the person to do both.
Yeah, in fact, we were just talking that I was, before this podcast, looking at my own, in Illinois, we call it a medical power of attorney, and it also included that HIPAA language. So when does a healthcare proxy or medical power of attorney become effective?
In New York, it becomes effective when a physician has determined that you are not able to make decisions on your own. That could be, for instance, that you have gone into surgery and you are under anesthesia and there is a complication. It also could be that you've been in some sort of an accident and you're brought into the hospital without being able to say what it is that you want. It also could happen as people get older if they start to not understand where they are or what they're doing.
So how do you suggest that your clients decide who should be their healthcare proxy or their agent?
Well, the most important thing, first of all, is to talk to the person that you'd like to be your agent and make sure that they are able and willing to do it. It should not come as a surprise to them. They should know that they're on deck for that. This person needs to be somebody who will do what you would want. They are going to step into your shoes. You want to make sure that they want to do what you want. And they're not going to say, oh, I don't care what she wants. I'm going to do what I want to do. So you've got to trust that person.
Do you usually suggest to your clients that they also choose a successor or maybe even a contingent successor to that agent?
Yes, we do. We tell them to also pick somebody in case that person is unable or unwilling to act. That person might be unwilling or unable because you might be traveling with them. You could be in a car accident with the other person. So you definitely want to have some sort of person after that.
We were previously talking about HIPAA releases, but tell me more about the type of information that's accessible to that agent in that critical time when they have to make a decision.
Well, basically things about you, your medical record, illnesses you've had, medications that you're on. They may or may not know that you're on a medication. So they would now know that. This can come into play, for instance, with, if you are the healthcare proxy for a child who is over the age of 18, that child may be torn. On the one hand, they want their parent to help them if necessary. On the other hand, they may not want their parent to know that they're on birth control pills or things like that. And they would then have that information.
So can that agent get that information when the person is well and there's not an issue?
The healthcare proxy does not go into effect until you are incapacitated. A HIPAA release would go into effect for other reasons. And I'll get into that when we talk about the power of attorney. For instance, in New York, in a power of attorney, you can also include the HIPAA language such that somebody would be able to obtain your medical bills and pay them for you. And that isn't necessarily just because you are not able to. It could be that you're out of town. You've gone on an extended trip, or in the case of college students, again, you might be in France for the semester studying. And this way somebody could actually take care of that. Without that HIPAA language, they are not allowed to give you even the bill or say that you went to that doctor or anything.
So talk to me a little bit about clients describing their medical wishes. Do they do that in the healthcare proxy itself?
You can. A lot of times when you go online and you do the online forms, I have seen that they include everything under the sun. When you have one drafted by an attorney, it will say the things that you want the healthcare proxy to be able to make decisions about, the things you do not want them to be able to make decisions about. And you can also say when it starts and when it stops. So it's more personal to use an attorney.
What have you found have been the major issues that people definitely want to have memorialized in their healthcare proxy?
Well, generally their care. If they're, like I said, if they're on the table, they've had some sort of a problem while they're having surgery, and they now discover, for instance, that they've got to take out more organs or something like that. You need to discuss those wishes, and they need to be in the healthcare proxy, but it doesn't have to all be in the healthcare proxy. You can have a conversation. For instance, let's say you filled out the healthcare proxy 2 years ago, and now you're going into the hospital specifically because you're having a surgery. Mm-hmm. You might discuss with your healthcare agent specifically what things you would want and what things you wouldn't want. You might have changed your mind over time.
Yeah, Deborah, I don't know about you, but every once in a while I'm interviewing a client and they'll come to me and say, well, I don't really care. Whatever my doctor says, my agent should do. And then I start breaking things down a little bit where your viewpoints on artificial nutrition or, electrolysis or other things. And people start to have opinions on these things when you start to really break it down and to think about it. Let's shift gears just a little bit. Let's talk about powers of attorney. Financial powers of attorney. And I know that different states will call these different things. For example, in Illinois, we call it a power of attorney for property. But when do these become effective?
Okay, in New York, we just got a new power of attorney law a few years back, and it's very, very specific. we have a form called the New York Statutory Short Form, which goes over exactly what you do and do not want your agent to be able to do for you. You can have them, for instance, be able to do real estate transactions, banking, things like that. You can also give a power of attorney to different people for different purposes, and they could all be good at the same time. For instance, you might know that you're going to be out of town when there's a closing on a property. You can give a power of attorney to an agent just specifically for that particular closing, and it's only good for that closing. Now, we also have something where we have a gifting power, where if you're just doing the short form, the agent can only give $500 or less. And if you want them to be able to give larger gifts, you need to fill out another form that goes with that.
What are your thoughts on those special gift writers?
It's called a statutory gift writer.
What are your thoughts on it?
It depends. When you have an older person, they may want to give away money each year to people. Sometimes they do that because they want to be able to be, let's say, planning for Medicaid, which is something I don't do, but I'm aware of it. And sometimes you don't want them to be able to give those gifts because they might be giving away your money in a way that you don't want. Now, you do have to trust the person as your agent for the power of attorney. If you don't trust them, there are times when you think, okay, well, this is the person I want because I should, but I kind of don't trust them. You can have a monitor appointed, and the monitor would have to check on that person to make sure that they're doing everything in your best interest. Although our new power of attorneys are different from the way they were years ago. There are instructions to the agent, and it does not become effective until the agent signs in front of a notary, and they have to be, and they're doing that, they are reading that they are a fiduciary and they have to do what is in your best interest. That's different from the way that it was years ago when somebody would all of a sudden find out they were the power of attorney. Nowadays, they know they are the power of attorney and they have to sign and they have to read everything also. It's a more protective statute now.
Can a power of attorney testify on behalf of the principal?
Not in New York. They can sign for you. They cannot speak for you.
So you were just mentioning that the agent has to sign. Have you found that that's the requirement, that you have to notify the agent before they can be their power of attorney?
Oh, of course, the agent has to sign. They have to know that they're your power of attorney if they are signing, and they have to sign. It doesn't become effective until they sign. Now, the problem here is if you have somebody stepping into their shoes that they're unable and you haven't had them sign yet, then they may not be able to do it. So you need to speak to everybody, not just the one that you're naming first, but also the secondary person you also have to have the conversation with. And we also in New York, you can have two people acting together. So that's another way to make sure that if you're worried about somebody taking all your money, if two people together have to act, then it's a lesser chance that they'll be doing that.
Have you found issues, though, when those two agents have a lot of conflict and they can't really get on the same page?
Well, the best way to do this is to have a conversation with everyone and make sure that they would be on the same page, which should be the page that is in your best interest.
Yeah, absolutely. So I've heard this term for listeners. What is a springing power of attorney?
Okay, in New York, a springing power of attorney is one that only becomes effective upon a condition. So for instance, someone who's a business owner may have a springing power of attorney that enables someone else in that business to be able to take care of all of the financial matters of the business in case they become incapacitated. Whereas a regular durable power of attorney is effective immediately. That's the difference. The springing one springs from the condition.
Got it. All right, let's talk about living wills. And I don't know about you, but I feel like there's a lot of confusion on what exactly a living will is in comparison to, let's say, a last will and testament. So tell us about living wills.
Okay, so a living will is a document that could go hand in hand with your healthcare proxy. It basically says that you, let's say, don't want to be resuscitated if there's no hope for you to have a meaningful recovery. That differs from a last will and testament, which is the disposition of your property. And if you have minor children, who would be taking care of those children? They're very different. A living will is something while you are still alive, whereas a last will and testament only takes effect once you have passed away.
So, Deborah, I'd like to talk again about the HIPAA releases, okay? And I know that you had mentioned previously that you could put that HIPAA release language in the healthcare proxy, but I was curious about two things. Can you also include that HIPAA release information in a living will or a power of attorney? And can it be its own standalone document?
You can put the language into a power of attorney, which would enable someone to pay your bills for you and get that information. But you also can have a HIPAA release that is neither a healthcare proxy or a power of attorney, but just its own document. And that would be used in a case where you want to release information to another party, such as another doctor, a hospital, if you're applying for some sort of insurance, but that would not allow those people to make any decisions for you, just to be able to get your information. It's an important distinction.
Got it.
Way.
So where do you recommend that your clients keep the original copies of these advanced directives? Should they keep them in a safe deposit box?
Absolutely not. In my practice, what I do, first of all, is we try to do more than one copy. So there's more than one original. I keep a scanned copy just in case they can't be located. And I do recommend that people keep them in a waterproof and fireproof safe. The reason I do not recommend them keeping it in a bank safe deposit box is because you might need those documents. And if the bank is closed, you can't get them.
Mm-hmm. Yeah, that's a good point. By the way, I saw once an estate planning attorney have USB keychains that she gave to clients with electronic copies of powers of attorney and wills and things like that. So if somebody ends up in the hospital, then they're right there. Something that I've thought about implementing in my own practice, and I just haven't done it yet.
Well, maybe I'm a little paranoid, but what worries me about that is those could get lost. They could get changed. I have PDF scans. And I can scan that to the people who need it if they need it in an emergency, but I would then be able to know if I should or shouldn't be sending it. Whereas if it's on a keychain, I don't know. I mean, I'm not saying it's a bad thing. It's just something that there's a plus and minus to it.
Yeah, absolutely. Maybe it could be password protected on the USB. So somebody with some cognitive ability would need to be able to grab that and remember the password at that time. But good point there. So Deborah, tell me about what happens if you don't have a power of attorney, if you don't have a healthcare proxy, if you don't have a living will. What happens?
Well, New York passed a law a few years back where you can get a surrogate. And I mentioned this before, and it's sort of like dying intestate. There are certain rules as to who can be the surrogate. The first person would be a guardian appointed by the court. The second person could be, let's say, a spouse, etc. There's a whole demarcation of people. The issue with that is if you don't want one of those people in that order to be the person in charge, you have the opportunity with the advanced directives to say who you want. You might or might not want the order that they have in the law. And that's only if you're in a hospital, that particular law. If you're not in a hospital, then the healthcare proxy law would take over. And if you do not have one and you are not in a hospital, the family might need to go for guardianship, which is a long and costly procedure.
Yeah, it really is. So talk to me about what happens to these advanced directives upon somebody's death.
Well, basically, upon your death, they're no longer relevant. They completely are void. They're only for while you're alive, which is the exact opposite of a last will and testament, which only takes effect when you pass.
So we're both matrimonial attorneys. So let's talk about the big D, divorce. So what happens to these advanced directives when life is good, the marriage is good, perhaps you list your agent as your spouse, and then you're going through a divorce. What do you recommend to your clients during that process?
Okay, during the divorce, the documents are still good, which means if you've changed your mind, which is part of what I call divorce planning, we have estate planning, there should also be divorce planning. You should be speaking to an attorney before you file, before you go ahead and get that divorce about these kinds of things. You may want to name someone else, you may not. And if you do want to name someone else, you can redo those papers. If you don't, you need to specifically say within those papers that you want them to last through a divorce And if you don't have it saying that, you need to make new ones, because that way it'll be clear even after the divorce that it was made after the divorce and that you knew exactly what you were doing.
Yeah, I think that that's a really good idea. I mean, I don't know about you, but one of the first things I advise clients when when their divorce is complete is, please, let's take a look at your estate plan. What needs to be revisited?
Right. Estate plan should be revisited anytime there's a change in your life, whether it's getting divorced, getting remarried, having a child, any of those kinds of things. It's very important.
So do you have any tips for our listeners, for those that are perhaps talking to an estate planning attorney for the very first time, about how to find the right person, the right fit for them?
Well, I would definitely want to take a look at their intake forms, because you can tell by the intake forms how comprehensive they are. There's a lot of questions they should be asking you. I'm frequently asked, what's the difference between you and getting the forms online? And the difference is that I'm going to ask the right questions and give you the correct advice for you. So you definitely want to speak to a couple of different attorneys, make sure that they're not just giving you a run-of-the-mill form, that they're really asking you all the right questions. And you'll say, well, how do I know what all the right questions are? I'm not a lawyer. But if they're basically just assuming things about you, that's a red flag. You want them to ask you, not only, whether you're married, not married, children, all of those kinds of things, but do you want your former spouse to have anything to do with this? Because that's a valid question.
Yeah, I think that those are great points, so I think there's a lot of variation among attorneys in general, but especially estate planning attorneys. Yeah, I think that the key here is for our listeners to make sure that they go to somebody who really does this. Don't just go to your local attorney who maybe does everything, right? But somebody who really focuses on, farm, estate, and succession planning, to really make sure that they have those advanced directives done correctly.
Oh, for sure. You want to know if this is a major part of their practice or not. There are some attorneys who will say, oh, sure, I can do that. There's a form online, and they may or may not be giving you the best advice.
Yeah, absolutely. Well, thank you, Deborah. Thank you for your time. I know this is our second podcast recording, and I hope our listeners, if you have not listened to Deborah on our podcast on wills, to go back and make sure to listen to it now.
Thank you, Carrie.
Today's question for Ask Carrie comes to us from an agriculture producer in central Kentucky. He asked, what happens to my student loans when I die? Well, I will be glad to get rid of those student loans one day myself. Hopefully I don't have to die to get rid of them all, but that might actually be the case. So to answer your question, you have to first ask, what kind of student loans do you have? So if you have federal student loans like me, the good news is that, yes, if you die, then your loan is automatically canceled. That used to be the joke that that's the only way that you can get those loans discharged, because they are not dischargeable in bankruptcy. So federal student loans are canceled upon death. But those pesky private student loans, fortunately, I don't have any of these, but for those of you that do, the answer to that question depends on the borrower. Some of the borrowers might say that upon your death, the student loans go away, but others might say that they will pass with your estate and your estate will be liable upon your death. So I would check with the borrower there. If you have any questions on interpreting the terms of that loan, please speak to an attorney licensed in your jurisdiction. So if you have a refinanced student loan, and I know that I've refinanced my student loans a time or two for sure, but when you refinance a loan, the new terms apply. So if you had a federal student loan and you refinanced it to be a private student loan, then it's now a private student loan. And so you need to check with the borrower on those terms. Okay. So if you have a Parent Plus, and I'm not as familiar with this kind of a student loan, I don't have this. I think this is a newer type of a student loan. But when a parent takes out a plus loan to help pay for a child's education, and either the parent or the child later dies, the federal government will forgive the debt. However, if the student dies, the borrower, which is the parent, may receive a 1099-C form, which treats the wiped out debt as taxable income. So, the government will be there on the other side, wanting you to pay taxes on basically that forgiven debt. So finally, if it's a co-signed student loan and the primary borrower passes away, then you're still on the hook for the debt. As the co-signer, if you die, the primary borrower may be required to pay back the entire balance of the student loan in full. In this event, it is essential that the primary borrower check the lending agreement and discuss the situation with the lender to see what relief, if any, may be available. I have some more information on this actually on my website. I blogged about this several months ago. So if you just go to rinkerlaw.com/blog and search for student loans, you should also be able to find some more information there. If you have a question that you would like for me to answer on this podcast, please email me at Carrie@rinkerlaw.com, spelled CARI, at rinkerlaw.com, spelled RINCKERLAW.com. You can also find me on a slew of social media platforms, including Twitter, Facebook, LinkedIn, Snapchat, Instagram, and YouTube. In addition to that, you can find this podcast on YouTube. Make sure to subscribe there. Looking forward to the conversation.